Morning. As soon as I'm sure we've got a connection with everyone, we will proceed. Mr. Robinson, can you hear me? Ms. Taylor, can you hear me?
Yes, I can hear you.
Mr. Robinson, if you can hear me, your microphone is muted, so I can't hear you. Well, I may need to try a telephone number. Let me see if I can find one. Mr. Robinson? Mr. Robinson? All right, I have a phone number. Let me try that.
Thank you. Somebody please help me here. Good morning.
Good morning, Mr. Robinson. I see there's another attempt to sign in. Let me see.
Yeah, I went over to the phone. I said, let me switch over to the phone. I know this one is a lot simpler, but let me close this other one out here. That was on my laptop. I'll close that one out so I don't cause any confusion anywhere there. And I'll be back on Zoom on the phone. Let's see all now. Cancel and put this out. Okay. Should be on the phone. Let me see here. Okay. Is that better now? Let's see with dial in, or do I push dial in here?
I can hear you over the phone, so
okay.
let's just go with that.
I'm trying to get in now. It's asking me, do I want to dial in or Wi-Fi or cellular dial in? It's asking me that. Which feature I want there? I can see the courtroom now.
Yeah, we can see you. Why don't we just? Video? We lost the video.
I'm unplugged the headphones.
Wi-Fi. You're using the device.
Hear me, John?
Yes, we can now hear you. And I'll remove the other device.
Okay, great. Thank you. Sorry about that.
No problem. Okay, Shannon, you can put us on the record now.
My air conditioner off here.
Okay, we are back on the record to continue an evidentiary hearing in the matter of Robinson versus Taylor. Mr. Robinson and Ms. Taylor are both present, as is Ms. Taylor's attorney, Ms. McCluskey. And Ms. McCluskey, I don't rightly remember where we left off. I know it's been a while since we had our last session. Maybe you could bring me up to speed.
I hope so. Kind of a unique situation, obviously, as the court's aware, Mr. Hotchkiss was appointed and then the county lost that funding. So we're back. One kind of preliminary issue, from my notes and my recollection, I think my client wrapped up her testimony and we did start with Mr. Robinson's testimony. I don't believe we got fully through that before the court indicated it might be a good idea to appoint a guardian, and we were going to request the same at that time. So I think that's where we were at. Having said that, it just came to my attention that my client gave some additional information to Mr. Hotchkiss that's going to be very important to the court, and she did not retain copies of that. So I guess I'll leave it in the court's discretion as to how it would like to handle or proceed today. But I need to request that information from Mr. Hotchkiss if I could, and then in which case I would ask the court to be able to recall my client because it is new information, or at least for rebuttal purposes. It looks like text messages and emails directly from Mr. Robinson, essentially confirming his involvement with some prostitution activities and heroin use. So I also happy to amend our motion if that would help the court to include this new information. If the court,
I don't believe it's necessary to amend anything, even if it's recently developed information. If it bears on the best interest factors, I can certainly receive testimony of more recent events. So Ms. Taylor had some text messages from Mr. Robinson?
Yeah.
So Rebecca, I did email them to your email. So I did have a copy that I did send to you this morning.
Okay. Is it the extent of everything you provided to Mr. Hotchkiss? Because it's my understanding there's additional information that I don't have.
Yeah, probably. I can't remember what all I gave him. This court date's been going on for quite some time. So
yeah. And I received some, but it doesn't sound like from our conversations that it was everything that you had. So because of the significance of what seems to be in that documentation, I think it's best that I'm able to secure that for Mr. Hotchkiss. We can proceed with Mr. Robinson's testimony if the court wishes to do that today. I may have a little bit of a difficult time finishing a cross-exam without this information though. Additionally, we do have a rebuttal witness in Miss Taylor's sister, who, if the court remembers, was the individual appointed to do the parenting time exchanges at our last hearing in the interim. And she actually had to have emergency surgery this morning.
It was my other sister, not the one that picks them up.
Oh, okay. I'm sorry. So another rebuttal witness.
All right. Well, my notes.
And if we are to need an additional date in the near future, or when the court's docket allows, I don't anticipate it would take long, this additional testimony, the rebuttal.
Hold on just a second. Let me check what was the last date that you were present?
Should have that right in front of me.
Well, wait a minute. Never mind. I've got it.
Okay.
Okay. Let's see.
I did also discuss the possibility of whether the parties would agree to, because I think Mr. Hotchkiss actually finished the bulk of his investigation from the information the court and I received. It sounded like he was only waiting for contact from Mr. Robinson. I think he interviewed the child, I believe, or maybe he did not, but he did review all of the information, interview my client, and it sounded like his investigation was complete other than that last component. And I did query at least my client as to whether she may be amenable to covering Mr. Hotchkiss's fees to finish this investigation, because I think it would be kind of important. We have witness issues that are, it's a little difficult to get some witnesses who are giving my client information to give us addresses for subpoenas and to appear, because they're a little, they've got some trepidation about testifying to what their knowledge is. So that's been difficult. So I do think the guardian would still be helpful. And if Mr. Robinson would also be amenable to that charge, obviously the parties would be responsible. I think we both know Mr. Hotchkiss works very efficiently, and he could probably give the clients a very good idea of what the cost would be. It's just another thought for the parties in the court.
So it only appears that I heard testimony from, well, it's not clear. I did hear some testimony from Mr. Robinson. Mm-hmm. So to sum up, what you're telling me is, although we could take additional testimony today, we're not going to be able to complete because you have additional witnesses who aren't available. And in order to be properly prepared to cross-examine Mr. Robinson, you need this additional material that Mr. Hotchkiss is in possession of.
Yep, it is my understanding. Yep, and I've seen a snapshot of it, and I can confirm it does appear in writing that it's confirming some involvement with prostitution and heroin use. So it's pretty significant, considering we have been bringing these allegations in front of the court for quite some time, but it's difficult to get proof.
All right, well, hold on a minute. I want to get this thing wrapped up for everyone's sake.
Yes.
So I'm going to explore as quickly as I can get you back in here.
That would be great.
So I'm going to take a quick peek at my calendar over the next couple of weeks.
I'm happy to, depending on the party's availability in the court docket, I'm happy to, on any given day, be as available as early or as late as possible as well, if that helps.
Do you believe you could have everything you need and be ready to proceed next Thursday afternoon? That's April 22nd.
Yeah, absolutely. I could be ready. Judge Rapley did put an off day on that day for a termination hearing. It's my understanding that the clients, both parents intend to release, but we all know how that happens if they don't show up.
Is that scheduled for morning or afternoon?
Well, actually, it starts at 9. I don't.
Let's try it then. If you end up being tied up in her courtroom, we'll figure it out then. Is everyone else available at 2 p.m. April 22nd?
Not a problem on my end.
Absolutely.
All right, we'll see you back here then. 2 o'clock, April 22nd.
Great. Thank you, Judge.
All right, thank you.
Thank you.
Have a good day, everyone.
Everyone, thank you.